the company or their creditors, or sometimes they fail to pay revenue to the government and they circumvent the taxes that they have to pay. So when the members of the company, they want to make fraudulent use of the incorporation of the company, want to defraud the creditors or other stakeholders, and try to use the company to their own vested interests, then it's necessary to expose the promoters. Although the company is a separate legal entity, which has a separate property and has a separate, the obligations and rights. But sometimes it requires that the government agencies who are investigating in some frauds or any other such acts by which the stakeholders, their interests are put at stake. So in such cases, the government exposes the owner or the real formers of the company or the promoters of the company. We had taken up the sixth point, where the number of members falls below the statutory minimum. Now, under the Companies Act, it is required that a private company should have at least 2 members, and a public company should have at least 7 members. So in case the number falls below 2 in case of a private company and below 7 in case of the public company, in such cases, if the business is carried out for a period of more than 6 months with such reduction in the number, then the current members who with the company, they are personally liable for the debts of the company. Then where the prospectus includes a fraudulent misrepresentation, it is required particularly by the public company. The private companies, they need not issue a prospectus for the flotation of shares of the company. The prospectus is basically used for flotation of the shares of the company, for the subscription of their shares by the members, by the general public at large. So it's basically related to a public company, where a public company may issue a prospectus or may not issue a prospectus. So if the public company desires to get shares subscribed by the general public or offers the shares to the general public, then a prospectus is to be issued for the general public, and that includes this prospectus. It includes all the information relating to the promoters, relating to the past acts of the company, relating to any the holding company which is promoting that particular company, or and the balance sheet of the promoting company or the holding company. So all such information and profit and loss account and all such type of information is disclosed in the prospectus. Sometimes an existing public limited company may issue a prospectus about its own working in the past. So there can be exaggeration in the say in the performance of the company in order to lure the shareholders or prospective shareholders to subscribe to the shares of the company. So in such cases where a fraudulent misrepresentation has been made by the company, then the company's directors or promoters, they are responsible for this fraudulent misrepresentation. There may be a case where sometimes the companies do not issue a prospectus. So if the shares are to be allotted only to the members, or to the persons who are known to the promoters privately, then the prospectus need not be issued by a public company. In lieu of the prospectus, it's only a journal statement is issued, and that serves the purpose for the registration of the company and for issuing the certificate of for commencement of business by the registrar of the company. So when the shares of the company, they are floated to the general public, then only the prospectus is issued. And since the general public does not have any idea about the promoters or the past, performance of the company, so if fraudulent information or misrepresentation of the facts is made by the directors have to be exposed and hold responsible for that misrepresentation. And that may, in case they do such type of acts, they are liable to be punished by imprisonment as well as fine. Then holding and subsidiary companies. Holding companies, basically they are the mother companies, where those companies, they hold a major share in the in that particular company that they float, or the subsidiary company. And the subsidiary companies, they have a major shareholding of the holding companies. So basically the holding companies, they form the subsidiary companies and they hold a major share in the subsidiary companies. A holding company may be a public company and a subsidiary company may be a private company. The investigation into related companies. Sometimes the holding and subsidiary, sometimes, since holding companies and subsidiary companies, they are also separate legal entities. So the holding company does not have any liability with respect to the subsidiary companies. But in case if the holding companies, at the annual general meeting of the holding company, the results or the profits made by the subsidiary companies, they are discussed, and so in such cases the holding company and the subsidiary company may be treated as one by the government. And in case of any fraud by the subsidiary company, sometimes the holding companies may also be held responsible because they hold a larger share in the subsidiary companies. So it's necessary to expose the directors of both the holding companies as well as the subsidiary companies. Then investigation into related companies. Now, any company may have a number of, sister companies, or there may be different subsidiaries which may be related to each other. And naturally, the promoters, they may be having interest in some other companies, a major stake. So sometimes investigation is made in case there is a fraud. So it's necessary to expose the directors of the related companies as well. For investigation of ownership of a company. So again, when the promoters, they have a vested interest in the company, and the company is used as an agent of the investors or the promoters, and the promoters, they use the company for their own, to satisfy their own ends, to satisfy their own interests. then in such cases, the ownership of a company is to be investigated, and all the members of the company, they are exposed, wherein the course of winding up of a company. Now, in case a company is wound up, once a company is formed, it's formed for all times. The company is an artificial person, and it continues to live forever unless it's wound up. The directors, the members may change hands, their offsprings, or the shareholding may be transferred to some other new member. But where sometimes it's necessary to wind up the company has contracted a lot of debts, and is not able to pay those debts to the creditors. So sometimes it's necessary to wind up a company. In such cases, the real the promoters or the members of the company, they are to be, then their names have to be exposed, because those members will be personally liable, particularly in case of a company that's limited by guarantee, or a company with unlimited guarantee, with unlimited liability, sorry. So a company with unlimited liability or company limited by guarantee, in a case of company which is limited by guarantee, usually such companies, they have their, sometimes they have those funds which come up as a result of donations or sometimes grants, and then the members or the promoters, they guarantee a certain amount that in case of the winding up of the company, they will be accountable for the debts of the company personally. So when the company is wound up, so in case of the winding up of the company sometimes, in case of the company which is limited by guarantee, the members, they have to pay that particular amount to clear the debts of the company when the company is wound up. Whatever sum they have, or the total or the maximum sum that they have guaranteed, so up to that limit, they are responsible for paying the debts of the company, and they are personally responsible for paying up the debts of the company. In case of the company which has unlimited liability, just a minute. So in a company which has unlimited liability of the members, they are accountable for clearing the debts of the company up to the last rupee that they have to pay, or the company has to pay on winding of the company. Is anything related to this slide which is not clear or needs further explanation? No. Now, the illegal association. Now, if there are more than 10 members uh, in case of banking business, or more than 20 members in case of any other business, and that particular business is not registered under the Companies Act, it becomes an illegal association. So if that particular association of more than 10 persons in case of banking business, or more than 20 persons in case of any other business, if they are not registered under the Companies Act or any other act, like for example Partnership Act or any other act, Cooperative Act, if any such association that's not registered, it becomes an illegal association. So every member is personally liable for all the liabilities incurred in the business. And as we had in the last slide, we talked that if the number reduces in a private company from less than 2 or less than 7 in case of public company, the liability of the members is full for the debts which are incurred by the company when the number is so reduced for a period of more than 6 months. So if the membership is not, increased up to that required level, then all the members, they are personally liable. So these illegal associations where the statutory number of members is either reduced in case of private company or public company, or in case of such associations where the number is more than 10 in case of banking business and more than 20 in case of any other business, and the association is not registered, it becomes an illegal association. So every member is personally liable for all the liabilities incurred in the business. Members are punishable with fine. Such an association cannot enter into a contract. So if it's an illegal association, that means when the numbers are such reduced to, more than 10 in case of banking and more than 20 in case of any other business, and it's not registered under any act, then such association cannot enter into it. It's not a valid association, cannot enter into a contract. Such an association cannot sue any of its members or an outsider, not even if the association is subsequently registered in. So for the period when the membership and when the association is not registered, it cannot sue any of its members because it cannot enter into any type of contracts. And if subsequently, say after 6 months or after 1 year, that particular association is registered, so for the past any such type of agreements which the company has undertaken, it cannot recover any dues or any borrowed, lent amount from any of the members or any other stakeholder. It cannot be wound up even under the provisions relating to the winding up of unregistered companies. So it cannot be wound up because it's not registered as a company. So where the business has been carried on for some years, none of the members can sue for partition because it's not a legal association. So legally, there cannot be any partition of the business assets, or the illegality cannot be cured by subsequent reduction in the number of members. So if it's more than 20, for example, in case of any other business, the illegality cannot be cured by subsequent reduction in them unless the membership is reduced after that and it's then registered under the Companies Act. But for the past say agreements or past debts or past say, rights of the company or liabilities of the company, that association, um, that cannot be cured. If any sum is due for the company, it cannot be recovered, even if the members are reduced, and because for that particular period, when the membership of that association is more than 20, for such period, naturally it is an illegal association, and whatever debts are due to be paid to that association, they cannot be recovered legally. The profits made are, however, liable to assessment to income tax. So for the private businessman, for the shopkeeper, everyone has to pay the taxes. So even if it's an illegal association, it has to pay tax. It cannot be exempted from the taxation. Is anything related to this slide, or shall we move? I think everything is clear. Nothing very technical about it. So we'll move on to the next slide. A private company. Now, what is a private company? A private company is a company that is formed with two members. There have to be two members at least for formation of a private company. And for a public company, there have to be 7 members at least. And the private company as well as the public company have to be registered with the registrar of the companies. Usually the word private limited is written after the name of that company in case of a private company, and in case of a public company, the name is written as the public, as after the name of the company, it's just limited company. Whether it's company limited by shares or by guarantee, or is a hybrid company where part of the liability is with respect to the limitation of the shares allotted and partly by guarantee. So a private company the shares of the private company, they are not transferable freely. But in case of public company, they are freely transferable. Then maximum number of members in a private company, they have to be only 50. They cannot exceed beyond 50. In a public company, there's no restriction. Public company can offer shares to the general public, and there may be innumerable shareholders of the company or the members of the company. Right to transfer of shares is restricted in a private company. The restricted is not, freely transferable. Although the shares can be transferred from the member to his offspring on the event of the death of a person. So there's restriction on the right to transfer the shares. But in a public company, they are freely transferable. Then right to issue prospectus. In a private company, it's not necessary to issue prospectus. Private companies, they can offer share to their family members, their friends, their relatives, the known persons in a private way. And but then this number should not exceed 50. So they need not issue any prospectus. But the public company, they have to issue a prospectus in order to float the shares of the company to the general public. In case a public company does not want to issue shares to the general public, then it need not issue a prospectus. It will only issue a statement in lieu of the prospectus, and that statement will have to be submitted to the registrar of the companies, then only the company will get a certificate to commence the business. So in case a public company wants the general public to subscribe to its shares, then only the prospectus is issued. And if the public company does not want to offer the shares to the general public, then it need not issue a prospectus, but in lieu of the prospectus, it will issue a statement, and that statement will be submitted to the registrar of the company. Then commencement of business. So in a private company, immediately after receiving the certificate of incorporation. Now, this certificate of incorporation has to be sought by the private company as well as the public company. The certificate of incorporation, where the company has to submit the memorandum of association and the articles of association along with the name of the directors of the company. The company is registered, and the company, after the private company, immediately after getting that certificate of incorporation, or when it's registered as a company in its name, it can start the business right away. It can float the shares and can start the business. But in case of a public company, although the public company also applies for registering with the registrar of the company, it provides 2 or 3 names which can be selected by the registrar, along with the memorandum of association and the articles of association and other information that is required to be submitted, along with the address of the proposed company and other details. The certificate of incorporation is issued, and then after that the company has to float the shares. So once the company floats the shares and the shares are fully subscribed, whatever shares the company offers, they are fully subscribed, then only the registrar of the company will issue a certificate to commence the business. And after receiving the certificate to commencement of business by the registrar of the companies, then only the public company can start start its business activities, otherwise not. So the private company can right away start its business once it gets a certificate of incorporation. This certificate of incorporation, it's just like a birth certificate where the name of the company is mentioned and whatever activities are to be undertaken by the company as stated in the memorandum of association. So such a certificate of incorporation, the private company can right away start with its business activities, but a public company can only start its business activities once it gets a certificate to commence the business from the registrar of the company. Then need to hold the private company need not hold a statutory meeting, but the public company has to hold a statutory meeting, and the proceedings and the minutes of the meeting, they have to be submitted with the registrar of the company. Then the private company can appoint the director by a single resolution privately, but the public company has to convene an annual general meeting, and then the directors would be appointed. And 2/3 of the directors retire by rotation. So through the annual general meeting of the shareholders of the company, the directors are appointed. Then uh, the private company need not file with the registrar written consent to act as directors or sign memorandum of association or enter into contract for their qualification of shares, while it's required by the public company that they have to file a memorandum of association, and that copy of articles of association are also to be submitted. And then whatever shares they usually want to get subscribed, that minimum subscription should have to be achieved. And in case of the subscription of the shares, the shares should be paid up to that level or up to that amount what the general public is required to pay on the shares. So in the directors, they or the members of the company, they are also to pay up to that amount of their the amount that they are required to pay on a particular share. For example, if 50% amount is to be paid by the general public, then the directors or the members of the company, they are also required to pay 50% to the amount of shares that they hold. Then retirement of directors, they do not retire by rotation, but at least 2/3 of the directors, they have to retire by rotation. And the selection of the new directors are made in the annual general meeting of the shareholders of the company. Then increase in the number of directors. Directors can be increased to any extent without the permission of the central government. But in case of the public company, if the number is to be exceed beyond 12, then the approval of the central government is to be sought for increasing the number beyond 12. Then a number of members to form the quorum. Only 2 members, they form the quorum. In case of private company, in order to take important decisions. In case of public company, it's 5. Then there's no restriction on managerial remuneration, particularly like, for example, the managing director or working director of the company, whether it's managing director or any other director. But in a public company, there are restrictions because the general public is involved, and the general and public, they are the shareholders, the major shareholders of the company. Then minimum paid up capital is 1 lakh in case of private company. This has to be basically, in order to be registered as a private company, they should have a minimum paid up capital of 1 lakh. But in a private public company, they have to have a minimum paid up capital of 5 lakhs. So these are the distinctions between the private company and the public companies. Any thing that is not clear in these slides? We still have 2 or 3 minutes left for this session. No issue? Okay. Now the conversion of a private company into public company. So that's not very difficult. Private company can be converted into a public company when a resolution in the general meeting to alter its articles, that is the memorandum of, articles of association of the company. If those articles, there's a resolution in changing those articles, then it becomes a private company can become a public company. On the date of passing of the special resolution, the company ceases to be a private company and becomes a public company. And within 30 days of the passing of the special resolution, the company shall file with the registrar a copy of that resolution along with the prospectus or any statement in lieu. If the private company which has converted into a public company wants to get shares or wants to allot or offer shares to the general public, then it has to offer a prospectus, or if it does not want to offer shares to the general public, then a statement is to be submitted to the registrar of the companies in lieu of that prospectus. In case of default, in filing the resolution in the prospectus or the statement in lieu of the prospectus, the company or every officer in default shall be liable to a fine of 5,000 for every day of default. If the number of members is below 7, steps should be taken to increase the number to 7, while the number of directors should be at least increased to 3. And the word private is deleted from the word limited in the name. So it's just the name of the company and limited after that. So if the number of members is below 7 naturally and the business carried out for a period of more than 6 months with such reduction in the number, then all the members, they would be personally liable to the creditors.